Changes made by the 43rd and 44th Amendment Act are summarized in Table 4. Briefly speaking, the 43rd Amendment Act 1977 simply repealed those provisions which had been added by 42nd Amendment Act to curb judicial review. Article 31D, 32A, 144A, 226A and 228A. The changes made by the 44th Amendment Act are more extensive. It is not only omitted some more of the article which had been inserted by the 42nd and Article 257A, 390, 329A, but also made amendment in the other article in the order of restore this provision to the 96 1976 text is in Article 226. Apart from this combating the mischiefs introduced by the 42nd Amendment, 44th Amendment Act introduced additional changes by omitting the fundamental right of property in Article 19(1)(f) and Article 31(2). Since the Janata government failed to secure passage of a number of clauses of the 44th Amending Bill, the stamp of 42nd Amendment of various provisions such as the Article 368 still remain. Besides, the Janata government have themselves written some of the provision amendment by the 42nd Amendment which they considered by beneficial. Article 74(1), Article 311. On the subsequent amendment 73rd and 74th Amendment Act 1992 deserve special provision, special mention insomuch as they have introduced the electoral system for the composition of the units of local government below the states, the panchayats in the rural areas and municipalities in the urban areas. Dangers of frequent amendment. If evident that instead of being rigid, as some critics suppose that during the early days of Constitution, the procedure of amendment has rather improved to be flexible in view of easy with which as many as 105 amendments have been made during the 71 years of the working of Constitution. So long as the party is power, the center has a solid majority in Parliament and is more than half of the state legislature, the apprehension of impartial observers should be not upon the difficulty of amendments, but as the possibility of its being used too often either to achieve political purposes or get rid of judicial decisions, which may appear unwholesome to the party in power. Judges may to causes error and to already been demonstrated. Even the highest tribunal is likely to change its view in the light of further experiences. In the absence of serious repercussion for emergent circumstances or special contingencies, admit Sikkim by the 35th and 36th Amendment. Therefore, process of constitutional amendment should be restored for the purpose of overriding unwelcome judicial verdict on often as would generate in the mind of lay public the irrelevance of the judiciary, thus the shaking the very foundation of constitutional government. The Honorable Supreme Court finally settled the law that the all amendment to the Constitution made on or after 24th April 1973, by which ninth schedule is amended by inclusion of various laws therein, shall be tested on the touchstone of the basic or essential feature of the Constitution, as reflected in Article 21, read with Article 14 and Article 19 as the principle underlying them. Now, there is no blanket protection available but to the law inserted in the ninth schedule by the Constitutional Amendment on after 24th April 1973. It shall be a matter of constitutional education by examining by the nature of extent infraction of the fundamental right by the statute sought to be constitutionally protected.